So the law imposes two separate, different standards in determining whether an employer is liable for sexual harassment. These standards will depend on whether the person that is alleged to have engaged in the harassment was a supervisor of the alleged victim, or alternatively, whether the person who is alleged to have engaged in the harassment was a non-supervisory co-employee. So depending on which of those categories you fall into, there's different standards that apply. The employer is liable for harassment by a non-supervisory employee only if the employer A, knew or should have known of the harassing conduct, and B, failed to take immediate and appropriate corrective action. This is effectively a negligence standard. Right about now, you must be wondering, well, what's the definition of a supervisor for purposes of all of this? A supervisor is defined by statute to mean any individual having the authority in the interests of the employer to hire, transfer, suspend, lay off, recall, promote, discharge, assign, reward, or discipline other employees, or the responsibility to direct other employees, or to adjust their grievances, or effectively to recommend that action if in connection with the foregoing, the exercise of that authority is not of a merely routine or clerical nature, but requires the use of independent judgment. Where the alleged harasser was in a supervisory role vis-a-vis the alleged victim, there the employer is strictly liable for harassment by a supervisor, whether or not the employer knew or should have known, or whether or not they failed to take immediate and appropriate corrective action does not come into the question. An employer is strictly liable for the harassing actions of its supervisors and agents. But an employer is only liable for harassment by a coworker if the employer knew or should have known of the conduct and failed to take immediate corrective action. A supervisor who personally engages in sexually harassing conduct is personally, he himself or herself, is liable for sexual harassment. Second, if the supervisor participates in the sexual harassment or substantially assists or encourages continued harassment, the supervisor is again personally liable as an aider or abettor of the harasser. Third, the employer is vicariously and strictly liable for sexual harassment by that supervisor. On the other hand, a supervisor who without more fails to take action to prevent sexual harassment of an employee is not personally liable as an aider and abettor of the harasser, an aider and abettor of the employer, or an agent of the employer. So in that case where the supervisor has not taken an action to prevent the harassment, that supervisor does not have personal liability, although the employer probably does. Strict liability is not absolute liability in the sense that it precludes all defenses. Even under a strict liability standard, a plaintiff's own conduct may limit the amount of damages recoverable or bar recovery entirely. If the employer establishes that the employee, by taking reasonable steps to utilize employer-provided complaint procedures, could have caused the harassing conduct to cease, the employer will nonetheless remain liable for any compensable harm the employee suffered before the time at which the harassment would have ceased, and the employer avoids liability only for the harm the employee incurred thereafter. This is known as the avoidable consequences doctrine under California law. The avoidable consequences doctrine is a defense, and it has three elements. Number one, the employer must have taken reasonable steps to prevent and correct workplace sexual harassment. Number two, the employee unreasonably failed to use the preventative and corrective measures that the employer provided. And number three, reasonable use of the employer's procedures would have prevented at least some of the harm that the employee suffered. This defense will allow the employer to escape liability for those damages, and only those damages that the employee more likely than not could have prevented with reasonable effort and without undue risk, expense, or humiliation by taking advantage of the employer's internal complaint procedures appropriately designed to prevent and eliminate sexual harassment. This recording is strictly for legal education purposes and is not intended as a solicitation of business nor as legal advice. If you believe you may have a case against your employer, you are encouraged to contact competent legal counsel at your earliest opportunity. You may reach out to Benjy Law Corporation for a free consultation. We can be reached at 310-203-2650. You're also encouraged to check out our website for more information at www.benjylaw.com. That's www.benjy like yellow law.com. Thanks for listening.